I stopped the mic in the media.
Okay.
Yes, it looks like it's showing up correctly.
Okay, cool. All right. All right, let's begin. Okay, so let me ask y'all a question for everybody that has a home that is a homeowner. If you have a mortgage, all right, you don't have to comment anything. Just think to yourself, all right, have you done or have you checked on the chain of title? Now, most homeowners, 99% of homeowners, do not even know what that is. Now, if this is the first time you're hearing that, that's okay because you come to the right place and you're going to have a great understanding going into what you need to be doing. Okay. Now, okay. Now it says challenging MERS, chain of title authority. What every homeowner needs to know. Now, topics of the day, we're gonna cover MERS, what it is, and why it matters. Okay, chain of title. All right, your legal foundation. All right, also a step-by-step homeowner challenge strategy. All right, also remedy. Most homeowners' remedy, I would think, would be having a free and clear title, right? For any homeowner out there, wouldn't you want your home free and clear? Because if it's free and clear, that means I don't have to pay anymore, right? Should I stop paying until I have clearance from the court that my home is free and clear? No, I should not. I should continue paying until I get to that point, even though I can see, all right, it's gonna be a point in time where I'm not gonna have to pay anymore, and I'm gonna be able to get restitution. Okay. All right. We also gonna talk about apartment leases and see if the same rules apply. Okay. Now, again, this PowerPoint is dedicated to empowering homeowners with legal knowledge because most homeowners just think that they're the borrowers, they're the debtors, they're working to pay their house off. All right. And we want to be able to have, we want to be able to raise our negotiable or our negotiation power. Okay. With that being said, you have to be able to ask questions. If you don't know how to ask questions, if you don't ask questions, they're going to basically assume everything is right. Simple. Okay, so let's talk about it. What is MERS? All right, MERS stands for Mortgage Electronic Registration Systems. All right, the system built to hide the ball. Now, MERS defined. MERS, again, Mortgage Electronic Registration System, is a private electronic database created in the 1990s by the banking industry. So, again, it wasn't created by Congress. MERS was created by the banking industry. All right. Now, what was the purpose? Allow banks to buy and sell mortgages thousands of times without recording each transfer in the county land record, in county land records. Now, let me ask y'all a question. If we buy a home, don't we have to go and record the registration? All right. Don't we have to go record the transfer? Yes, right? Don't we have to pay a transfer fee? Yes. So isn't it unfair if MERS is finding ways not to pay the transfer fee, all right, when they're handling our mortgage? Because again, we could leverage that for our benefit and be able to get our homes free and clear if MERS did not do the chain of title correctly. All right. Now it says results. Now, what does this look like? MERS is listed as the nominee on the deed of trust, but MERS never lent you any money and holds no financial interest in your home.
Talking about
So,
MERS.
again, this is something that you have to ask yourself, homeowners. Is MERS, all right, a nominee on the deed of trust, all right, for my home? All right. Is MERS attached to my mortgage at all? Okay. Now, again, I'm going to give y'all a step by step exactly how you get to the bottom of that. All right, so don't worry, I got the solution for you. Now, key problem, when banks sold your loan on Wall Street, they broke the legal chain linking your note to your deed. Okay, MERS was the cover-up mechanism. All right, now the core legal flaw in most states, the note and the deed of trust must stay together to foreclose. MERS separation broke this. Now, a lot of people don't really understand this. You have to understand your home has two titles. There's the deed of trust, and then you have the note. Okay. Now we're gonna break that down. Don't worry. Legal principle: the mortgage follows the note. Now, if it's broken up and a company wants to foreclose on you, they can't foreclose on you if they only have one of the two. Both have to be present. And most time, both are not present. And think about how many people have gotten their homes foreclosed, and they didn't even challenge this. I'm saying it again. Think about how many people has gotten their homes foreclosed on and didn't even challenge chain of title. Okay, so meaning MERS is just out here taking homes. It ain't even got to be MERS. It can be another company. Because once it transfer hands, that company has to go make the registration, and they don't. All right, when they don't, they basically waive having to pay those registration fees. All right, and registration fees is based off the percentage of the home. So imagine somebody had a $3.5 million home, and the registration fee on that is, I don't know, 2%, 3%. Okay, depending on what state you are in. All right, now let's break down the chain of title. Your legal foundation, the public record that tracks who actually owns your property. Okay, now number one, the original lender loans you money, holds note, and deed. Now, I understand that the banks don't really give us anything, but remember, we utilize them as pass-throughs. Okay, so we give the banks powers to basically go inside of our safe, okay, and extend us our own credit. Now, again, you can't go to court and say that verbatim because the judge is going to laugh at you and say, "What are you talking about? What safe are you talking about? What?" You can't say my treasury account because now you have to show proof that there is a treasury account that you can control, and there is no way to show that proof. Okay, well, at least to the point where a judge is gonna say, okay, yeah, you're right. No, all right, got to be from another angle. So number one, again, original lender. That's who we basically originally signed the contract with. Most people that have mortgages, right after they sign the mortgage, 2, 3, or 4 months later, it goes to a whole nother lender. Okay, when that happens, there must be a registration fee that is paid. If not, the chain of title is broken. The only one that can basically raise this to a point or to benefit is who? The homeowner. So for anyone that has a home right now, let's say that you have you on to your third lender. It done changed hands 3 times. Okay, and let's say at some point along the line, someone did not pay the registration, did not do the recording correctly. Guess what? You can exploit that as the homeowner. Okay, because if they didn't have
Recording
authorization to
correctly,
make that
meaning like
sale, guess what?
when
Everything
they
has
did
to
the
go
deed build
back
up,
to as if it
how
was
they
if
changed the lenders.
equity was asserted, and we're gonna talk about that too. All right. Now I know for a fact, if I was a beginner, this probably would sound like Spanish. Okay, but again, y'all have to hear how it sounds. Again, it might not make sense right now, but again, going back to the phrase, wealth takes time. All this is going to take time. One day, this is going to click and say, okay, I see what he mean by that. All right. Number two, assignment. All right. Now we're going over the chain of title for those folks that just came in. Going over the chain of title, exactly how to get your home free and clear. Okay. Now again, the very first chain is original lender. That's who you're doing business with. Okay. You create the money, they loan it to you. All right. They hold the note and the deed. All right. The assignment is created. Okay. The transfer note plus the deed to the next party. Number three, securitization. Loan bundled up into a REMIC trust. All right. This is Wall Street. This is where the secondary market comes into play. Okay. The servicer collects payment, often not the owner. Now, let me ask y'all a question. If your mortgage, let's follow the chain of title. Okay. If it was all bundled up, all right, if it was bundled up into a REMIC trust and it went to the Wall Street on the secondary market, okay, why doesn't interest payments go to the owner? For all homeowners out there, I don't want you to hear that and get entitled like, yeah, they owe me money. All right, let's really break it down. You have to ask yourself, why isn't proceeds going to the homeowner? All right, why is proceeds not going to the homeowner? Oh man, I didn't mean to do that. Oh, 1 second, family.
Claiming your security interest is something very important to know. But
1 second.
if you're selling it, why am I not getting benefited from it?
Right. Data lake.
Okay. Trying to go back.
Can't be that cold.
All right.
You're not that cold, are you?
Everybody still see my screen?
Okay, take it off now.
Okay. All right. So again, chain of title. Number one, the original lender and you create the contract. Okay. Then the assignment comes. Then the securitization comes. Remember, your loan gets bundled up in the Remick Trust and it hits Wall Street. Okay. Then the servicers collect payments. All right. Often not the owner. Okay. Now, why is that? Because most homeowners do not assert their equitable beneficial ownership. It's just like insurance. Okay. Comment three, if you have any type of insurance, car insurance, rentals insurance, okay, cell phone insurance. All right. Now, what happens if that item gets damaged? You have to do what? You have to file a claim. Okay. All right. Let's say my car, gets into a wreck and I have insurance, but I don't file a claim. Does my car get fixed? Who has to pay for that? Me. Because until I file the claim, okay, it's as if nothing happened. So the same thing with all homeowners. All right. Same thing with leaseholders. If you're in an apartment, all right, that contract is waiting for you to assert yourself as the equitable beneficial owner, allowing the servicers to keep this security interest. Okay, you got to remember there's two titles. You have the equitable title, you have the legal title, which is the security interest. So if you look at your mortgage, it'll literally say you gave a security interest in the collateral. That is them basically reserving the security interest, and they're waiting. Well, I'm not gonna say they're waiting, okay, but the contract now needs the equitable beneficial ownership reserve because now both titles are sold up for, meaning are claimed. All right, because right now, if you have not claimed that seat is empty. All right, and that's why the services are able to collect payments. All right. Now, the last chain 5 is foreclosing party. It says claims rights to foreclosure, but can they prove it? That's the question. Most companies that foreclose, they just basically foreclose on the account of of the homeowner has not paid. But a lot of times, if the homeowner challenged the chain of title, they can literally see what's really going on. Like again, going back to, we can see if MERS did the registration correctly. Okay, because if we find out that the foreclosure that happened, okay, and they didn't even have authority to foreclose because the chain of title was incorrect, okay, we can assert equity at that standpoint. All right, now we have to talk about when is the best time to do that, because you don't want to wait to the last minute, or you don't want to wait to years later to try to do that. Okay. Now it says what breaks the chain. All right, missing or unrecorded assignments. MERS as a nominee with no real authority. Assignment signed after foreclosure began. Okay. Robo signed documents. Let's talk about it. Now, I have a scenario for y'all as well so you can follow along. Now, meet Marcus, a homeowner who woke up, real world scenario, learning the system and taking action. The scenario, Marcus bought his home in 2018. Hold on, give me 1 second. Y'all got hiccups.
Well, he be like really putting
Okay.
together. He be on
Marcus bought his home in 2018.
talking about
His
that.
mortgage was originally with First National Bank. He's been paying a company called Loan Serve USA for years, a company he never signed a contract with. Okay. Then his friends tells him, hey, check who actually owns your loan. Marcus decides to dig. Okay. Discovery number 1, his deed of trust lists MERS as a nominee, not First National Bank. Discovery 2, his loan was sold to Wall Street, Remick, all right, Remick Trust within 90 days of closing. Discovery 3, no assignment was ever recorded in the county recorder's office. All right. And a lot of people might say, well, why does that matter that they didn't record it in the county office? Because if they didn't record it where the property is located, that means they didn't have authority to foreclose or sell it. Okay. Comment 8, if that makes sense. I'm going to try to break it down as much as possible.
100%.
Okay. Whoever forecloses on the home. Now, I'm not saying just stop paying your mortgage and just go straight, cold turkey. No, I'm not saying that. I'm saying do your due diligence first. Keep paying, but also you can do your due diligence. You can see if they did the recording. That's easy to do. Okay. I'm gonna show y'all exactly how to do that. All right. Now, step 1, Marcus requests all documents, qualified written requests. All right, which is called a QWR. So if you ever see a QWR, it just means qualified written request. All right, and that's under RESPA. All right, also under 12 USC 2605. Please put that in your AI. If you have any issues, while we're going through this class, if it doesn't make sense, go ahead and kind of transfer some of this information to your AI. Ask it to break it down to you in the 10th grade level, 11th grade level, 12th grade level. Okay, because again, that's what it's about, fam. It's about finding your clarity, finding your clerical point. Okay, because if not, you're just gonna be saying, yeah, I get it. You're just gonna be storing information. It's not gonna be useful. All right. Now let's talk about Marcus taking action. Marcus sends a qualified written request, QWR, to the loan servicer demanding proof of ownership and authority. Now, again, let me ask y'all a question. If Marcus sends this, can they just foreclose on his home?
Absolutely not.
No, they can't. Because why would they? He has the right to ask questions.
Talk to brother.
Right. I don't know if
Ask him
anybody
to
was
talk.
here
I'm
when
listening to
a
something.
while back when we went over the
Because
basic
that's
consumer
considered
rights,
like
meaning we have the right to be
Mhm.
heard. Okay, we have
And
the
it's not
right to
foreclosed with the
choose.
active dispute.
Okay, we have the right to full disclosures. Meaning, if Marcus asks for these documents, the servicers can't say no. We don't got to show you that because now, for one, that looks suspicious. Okay, for 2, like, what are you doing? Like, what do you mean you can't show me this? I'm the homeowner. What do you mean you can't show me the accounting? You can't show me your authorization to this. How I know you have any ties to this? You
Well,
could
they
just be
failed one time.
telling
Let's
me
see what they
anything.
do with the one you sent to me.
Okay. Which often, a lot of times, is what's
Have to-
going on, man.
yeah,
It's
they're gonna have
crazy.
to
I'm
answer.
trying to tell you.
I told you
If you have a mortgage, okay,
You're gonna
you
have to
need to
understand
start
for the
doing your due
QWR to get
diligence.
that.
Meaning, don't rush. Take your time. Okay.
You didn't show it
Investigations
to me.
take
You
time.
talked
Take
about
your
it in the
time.
house.
I sent it to him.
All right. Now, what are some of
Yeah,
those
that's what they
requests
asked.
that Marcus is asking? He's requesting the original promissory note to see if they physically hold the wet ink note or just a copy.
Oh, this is
All right.
yeah,
Next, the deed of trust, the mortgage, to identify who was named as beneficiary and nominee. All right. Also, a complete chain of assignment, every recorded transfer from original lender to the current claimant. Also, a pooling and servicing agreement, proves if loan was securitized and under what trust rules. Also, MERS MIN number. All right. Look up, track every transfer inside the MERS system. All right. MERSync.org if you
They
want to
got
look
to
that
look it
up.
on my phone.
Okay. Payment history and also ledger. Verify proper application of all payments made. So that's 6 requests. Okay, these are 6 documents that Marcus is requesting for his mortgage. So yes, if you have a mortgage, all right, you want to request these documents. Okay, now let me ask y'all a question. How much do y'all think it costs to ask these questions? The only thing you're gonna be paying is mailing. That's it. All right, I keep doing that. My bad. Sheesh. Okay. All right, next slide. Step 2, Marcus analyzes what he got back. All right, spotting the defects, what to look for. All right, number 1, MERS is listed as the beneficiary, not the actual lender. That is a red flag. So again, if you look up your paperwork, look up your mortgage documents, and see that MERS is listed as a beneficiary and not the actual lender, all right, that is a red flag. Number 2, assignment signed by a MERS officer who was actually a loan serve USA employee. All right, that is called a robo signer. Okay. Okay, meaning you're signing saying that you're an officer for somebody else when you work for somebody else. Number 3, assignment dated 6 months after the foreclosure notice was sent. Also, servicer cannot produce the wet ink original note. 5, I apologize that the words is falling over. Pooling and servicing agreement says loan, all right, must have authorization. All right, I can see it, but I don't think y'all can see it on y'all side. Loan servicer must have authorization. Okay. It must have been deposited by 90 days cutoff, and it wasn't. All right. Now we're going over the key legal principles. You cannot transfer what you do not own. All right. Now imagine if I found one of y'all's deeds to y'all house and then I went to go sell it. How can I sell something I don't own? The only one that can sell is the owner. And if it's sold, the owner is supposed to receive proceeds. How many people y'all think got their home foreclosed and they received the check? Probably none. All right. So it says an assignment executed after a default notice is legally suspect and potentially fraudulent. Tools Marcus used. He used the county recorder website. That's free. He used MERS servicer ID, MERSinc.org. All right. He went to the SEC, SEC Edgar,
Yeah.
searched the Remick Trust, also the court records, prior foreclosure cases, trying to see exactly, as much evidence that he can have, because again, it's all about having evidence by the time he goes to court. All right. Meaning he's not even bringing this up to MERS right now. He's just collecting his data. He's just analyzing what he got back. That's it. He's not rushing. Okay. Step 3. Marcus' legal challenge strategy. Multiple avenues to attack invalid authority. Number 1, quiet title action. File a lawsuit. Okay. Again, file a lawsuit asking the court to declare Marcus the rightful owner with no valid lien. All right. Forces every claimant to prove their interest in court. All right. For those that don't know what a quiet title is, it's basically quiets all other claims. And if they have a good claim, then they better show proof. And a lot of times they can't. All right. And that's what it's about, fam. It's not about enforcing a negotiable instrument or a tender. It's about saying that these companies have authority to do what they're doing. Because if I can chop your legs out from under you, you can't walk. Okay. You can't walk or run. All right. Number 2, produce the note defense. Demand the foreclosure party produce the wet ink original note under UCC 3-301. Only the holder or a person entitled to enforce can foreclose. Number 3, standing challenge. File a motion challenging whether the foreclosing party has legal standing. The right to bring the lawsuit. Okay. If the chain is broken, they have no standing. Okay. Number 4, TILA. Again, TILA stands for Truth in Lending. Okay. RESPA violations. If servicer failed to respond to QWR, qualified written request, within 30 days, RESPA or failed to disclosure, all right, or to disclose true loan terms, which is also on the TILA 15 USC 1601, Marcus has a federal claim. All right, all right, so again, he didn't just rush and go sue them. He had, he had to build up the whole process. First of all, he had to go make sure MERS was as the beneficiary. And then when he looked up, bingo, they were.
I think
Okay.
you tell these things though.
So number 5, robo-signer fraud claim. Fraudulent assignments are void. Okay, not just voidable. File complaints with the state attorney general. You can file a complaint with CFPB and the OCC. Okay, CFPB stands for Consumer Financial Protection Bureau. Okay, and the OCC stands for who want to get that for me? Who knows what the OCC stands for? All right, anybody knows?
Office of Controller.
All right, I gotta go back and forth like this. All right, exactly. Officer of the Comptroller. All right. Okay, I'm looking at the chat right now, y'all. I just want to see if okay. Any questions while You know, as so far, I don't want to feel like I'm moving too fast. All right. Any questions so far? So do y'all does it kind of make sense so far exactly how you need to attack? You know, if you have a mortgage, okay, I'm gonna get to the lease information as well. Okay, but for those folks that have a mortgage, you really have to see like this stuff is free. You can literally just ask questions. Hey, I want the chain of title. Okay, you can check your county recorder, see if they did the transfer completely. All right, and correctly. Not just if they did it, see if they did it correctly. All right. So yes, the OCC stands for Office of Comptroller of Currency. All right.
Okay.
Can everybody still see my screen? Oh, let me go back.
I'm gonna pass my credit card. My 669 is gonna get declined.
All right, let me go back. Okay.
What do you have to get you to fix it back? But not having a fucking your license too.
All right. So again, that's the robo signer fraud claim. Again, fraudulent assignments are void, not just voidable. Again, file a complaint with the state AG, that's Attorney General, the CFPB, that's the Consumer Financial Protection Bureau, and the OCC, all right, Office of Comptroller of Currency. Use this as leverage in
Control of what?
litigation. All
Currency.
right, so this is where a lot of people stop it. All right, I remember following groups before I got results when I was a beginner. They only taught us how to, you know, file complaints with the CFPB, but they didn't tell us, okay, now we have to go take that and go sue. All right, everybody that's hearing me right now, remember, when you go file those CFPB complaints, those OCC complaints, I'm not saying don't file them, but don't think that's the end all be all. You got to remember, that's evidence for your actual litigation, all right, your actual lawsuit that you're going to do at court, if that makes sense.
Yeah, I'll watch.
Okay. All right, let's keep going. Number 6, PSA cutoff argument. If loan was deposited into a REMIC trust late, violating the pool and servicing agreement cutoff, the trust never legally owned the loan. Okay, so meaning if it got sold, everything is going to have to basically be done over. Everything's going to go back to its original state, or shall I say, its equitable state. Remember, equity is about fairness. Okay, fairness basically defeats fraud every time. All right, so I don't want you to think, oh man, but I already signed the contract. How do I change this? You change it by doing what we're going over right now, finding if there's any missing links in the chain of title. Okay, now let's talk about quiet title action. The homeowner's strongest weapon, asking a court to declare who legally owns the property. All right, what is a quiet title action? A civil lawsuit filed by Marcus in state court, naming all parties who claim any interest in his property and forcing them to prove it in court. Number 1, you want to file a petition. File in county where your property is located. Name MERS as the servicer, trustee, and any REMIC trust as the defendant. Number 2, list pendants. All right, record a notice of pending action with the county recorder. Clouds title and stops any sale.
No, he's not talking about
Okay, so this is how you beat foreclosure. If you're in foreclosure, you want to hop on this ASAP. Now, a lot of y'all aren't in foreclosure, so it's even better if you do this before it even gets to that point. Number 3, discovery phase. Force defendants to produce the original note, all assignments, plus the PSA and the trust certificates.
I'm listening to
Number 4,
something.
summary judgment.
Don't
If
wanna be
defendants
mean,
cannot
but you're not
produce
listening.
documents, move for summary judgment. Okay, court's rules in Marcus's favor. All right. Number 5, court's order. Judge issues an order declaring Marcus title free and clear of the invalid lien. Key statutes. All right. Most states have a quiet title statute. Examples: California CCP. All right, section 760.10. All right, also Florida section 6511. All right, you always want to confirm with your state-specific rules. Remember, everybody here does not live in the same state. So again, you want to go to your AI and ask, hey, what is my state rules and regulations? Okay, when it comes to quiet title status or statutes. All right, don't make it hard on yourself, family. Use that AI. I'm not going to say ask it to get you out of your debt. I'm not saying that. Get it out your get you out your obligations. All right, you want to ask specific questions. Hey, what is my state code for quiet title statutes? Okay. Now let's talk about Marcus's discovery
You
timeline from
need to listen to this.
awakening
You
to
don't need to
legal
be doing
action, a
anything right now.
6-month journey. All right.
You
Month
should be
one,
listening to
Marcus
something
learns
important.
about MERS, pulls the deed of
You're always
trust
doing
from
something
county
opposite.
records,
This is
sees
why you're
MERS
always
listed
stuck in
as
a
a
situation where you
nominee.
don't know what to do with
In month
when you're
2,
in
he
I'm
the
sends his
listening.
qualified written request to servicer.
You should be doing
All
research
right.
as you.
Certified
This
mail
is
to
something that
loan
you need to
service,
answer back to. So you
USA,
need to like
demands note,
do your
assignment,
research
and payment
while he's
history.
talking.
Month 3, servicer
You
responds
can learn a lot from
partially,
him.
receives copies, but no wet ink note. Okay. Assignment dated after default. Red flags confirmed. In month 4, consults a real estate attorney. Attorney confirms chain of title is
Target only
broken.
has the 8 pack of
Recommends
the phone
quiet
in there.
title and less
Wow.
pendants. Okay. Month 5, files quiet title lawsuit. Names MERS, Loan Serve USA, and the Remick Trust as the defendant. Less pendants is also recorded. All right. Month 6, discovery phase begins. The defendant cannot produce wet ink note or valid assignment. Marcus's attorney files for summary judgment. Now, again, Marcus, he hired an attorney. Now, if Marcus was fluent in the law, he could go ahead and operate pro se. I'm not saying y'all need an attorney. I'm just saying if you want to get one, you can. All right, because this is an open and close. It's not something that where I'm trying to get my lawyer to enforce my negotiable instrument. No, this is you getting a lawyer to enforce quiet title statutes. All right, that's that works hand in hand. But again, if you don't want to hire a lawyer, cool, you can operate pro se. All right, now talk about the remedy: free and clear title. What winning looks like for Marcus. All right, and what it means for you. All right, because I know a lot of people like, okay, what does it look like after I do all this? Do I still have to pay? I got you. It says liens removed. Court orders the invalid lien stricken from public record. No more mortgage clouding title. All right. Next, you got the quiet title order. Court issues a judgment recorded at the county. Title is now clean and marketable. All right. Also, free and clear title. Marcus owns his home outright. No monthly payments to a party that cannot prove ownership. So, do y'all kind of see where I'm going with this? So, again, if you're a homeowner and you see MERS is listed as a nominee, I would highly advise you to challenge the chain of title. All right, because you could possibly have your home free and clear, no more payments, and possibly get all your restitution back that you made
The
to
owner and
MERS.
takes us to the servicing.
Okay, damage is possible. If TILA and RESPA violations found, Marcus may recover attorney fees and statutory damages. Okay, now what the bank will argue, because again, they're not just going to let Marcus just walk in there and just, have his way. Okay, now what would the bank argue and how to counter it? Expect these defenses. So you kind of want to go ahead and prepare rather than wait until you get to that point. All right. Let's say the bank says MERS has the authority to assign. Courts have upheld this. Remember, banks is going to pull that. They'll say this. Now, you want to counter with this. Many courts have not upheld MERS authority, especially when MERS never held the note. All right. At this point, you want to cite your state's specific case law, demand proof they hold the note. Simple. Okay. And that's why I'm saying go to your AI and ask, hey, if I'm living in North Dakota, I'm asking, hey, AI, can you give me North Dakota's quiet title statutes when it comes to MERS, not properly handling chain of title? Okay. Next, let's say the bank say you received the loan proceeds, so you owe the debt regardless. You want to counter by saying owing the debt and foreclosure standing are two different things. Meaning I'm not even saying I don't want to pay. I'm not paying. I'm just trying to challenge who has foreclosure standing. That's it. So remember, y'all, don't get thrown off by what they're going to throw at you. All right, let's continue. It says, even if you owe money, they must prove they are the party entitled to collect and foreclose. Simple. Okay, let's say the bank say, well, the assignment was valid, even if signed after default. You can counter by saying an assignment cannot transfer rights the assignor no longer had. If the loan was already in the Remick Trust, the servicer had no rights left to assign. So how did they assign the rights over if they never had them to sign over from the get-go? Okay, so that's something we can challenge. Let's say the bank say you waived your rights to challenge by paying for years. I got a lot of clients that say, well, I've been paying for years. You think it's too late? No, it's not too late. All right. This is where you counter. Fraud is never waived by performance. Chain of title defects are jurisdictional, all right, and cannot be waived by payment history. All right. You want to challenge standing at any time before final judgment. Okay. Now, what about apartment leases? How chain of title and MERS issues affect renters too? The short answer, yes. If your landlord's property is in foreclosure, your lease rights are directly affected. Now, this is more so for private renters, okay? The PTFA, your federal shield, the Protecting Tenants Foreclosure Act. All right, I'm saying it again. The Protecting Tenants at Foreclosure Act 12 USC 5220 note requires the new owner after foreclosure to give you at least 90 days notice before eviction. Your lease generally survives the foreclosed sale. Okay. Now remember, a lot of times people, let's say you're in a private property and then all of a sudden the homeowner comes say, hey, I got to sell my house, you have to leave. Okay. You have rights that protect you. They can't just do that, family. All right. We're going to talk about what happens if they do. Who is your landlord really? If your building was mortgaged and securitized, the landlord collecting your rent may not have clear title either. The same merge chain of title issues apply to the building, just one step removed from you. Okay. It says your lease is a UCC governed contract. A residential lease is a contract under UCC Article 1. Terms must be honored. If ownership transfers, the new owner takes subject to your existing lease unless you are month to month. Now, action steps for renters. Check your county records. Is your building in foreclosure or less pendants? Know your lease terms. Okay. Fixed terms protect more than month to month. Also, request proof of ownership from your landlord. All right. This is legal in all 50 states. Okay. Pay rent by check or money order, never in cash. Maintain a paper trail. If you get an eviction notice post foreclosure, invoke PTFA. Remember that stands for Protecting Tenants at Foreclosure Act. All right. And that's 90 days rights. Consult a tenant's right attorney as well. Many offer free consultations. Okay, this is for those folks that's going through eviction. Let's say you had a landlord come and say, hey, I got to sell the home. You got to leave.
Yeah, wants me to make the payment now.
Okay, they have to give you 90-day notice. It says your legal arsenal, key statutes and cases, federal and UCC law that supports your challenge. All right, now RESPA 12 USC 2605 requires services to respond to qualified written requests within 30 days. Non-compliance equals damages plus attorney fees. All right, TILA 15 USC 1601. Truth in Lending Act requires full disclosure. For violations can give rights of recession up to 3 years after closing. UCC 3-301. Only the person entitled to enforce can collect a negotiable instrument. All right, this defines who can legally foreclose. All right, also UCC 3-309. Lost instrument rule. Even if note is lost, party must prove they had possession and right to enforce when it was lost. All right, Jesenowski versus Countrywide. This was back in 2015. U.S. Supreme Court. All right, ruled till a recession notice only requires written notice. No lawsuit needed within 3-year window. Okay, so meaning if you find this out within 3 years of living in the home, all right, you can exercise your right to recession. Now, I don't talk about that much, all right, because I say go ahead and try to cut a deal with the company, keep the home, all right, or you can keep the home, all right, and give the contract back, meaning you can still retain all the money because it was far from the get-go. Okay. Now, PTFA 12 USC 5220 protects tenants from immediate eviction after foreclosure. 90-day minimum notice, bona fide leases generally honored. Okay. All right, federal statutes, full research reference. Look these up, uscode.house.gov. Also, lawofcornell.edu/US codes. Also, consumerfinance.gov. All right, 12 USC 2601, 2616. All right, RESPA. RESPA stands for Real Estate Settlement Procedure Act. All right, 2605. Servicer must respond to qualified written request within 30 days. We went over that. Violation equals actual damages, also up to 2,000 statutory
So they're not putting
plus
30 days.
attorney fees.
It's fine.
All
The
right.
PWR.
Also, again, 15 USC 1601 through 1667 goes over TILA,
What they
which
do this
stands for
morning,
Truth in
they'll
Lending
tell you
Act.
about it every day.
1635, right to
Out there
rescind
working
within
on
3
it and all
years
that
for
other stuff.
improper disclosure. Again, that's the Jedzikowski versus Countrywide. That was back in 2015. Written notice alone is sufficient to rescind. Okay, 15 USC 1692 FDCPA, which stands for Fair Debt Collection Practice Act, bars abusive collection. If server is a debt collector, violation equals 1,000 statutory plus actual damages plus attorney fees. Okay, also 12 USC 2801 through 2811. Now, when you see, anytime you see the words number 12 in front of USC, all right, for everybody that doesn't know, that is the Banking Act. All right, if you see 15 in front of USC, that is Truth in Lending Act. Okay, 12 USC, again, 2801, 2811, Home Mortgage Disclosure Act. Lenders must report loan data useful in litigation to expose discriminatory lending or misrepresentation at origination. Now, what y'all remember we were talking about how we forgot to assert our equitable beneficial ownership in the beginning? But we did give out our security interest, so that seat is already sold up for. So they're basically, the contract is waiting for the equitable beneficial party to basically be a claim. All right. So up until the homeowner does that, there is a mischaracterization that is happening. They are considering you to be the borrower. Okay, someone that doesn't have equity. All right. Now I know some people say, well, I borrowed equity against my home. Yeah, but you did it the wrong way. All right. That was the wrong way.
What do you do?
Okay. Now again, I have a lot of people that ask me, well, if I ask my mortgage servicers these questions, do you think they'll put me through foreclosure? Not if you're paying your bills, family. You have the right to ask these questions. All right, they have to give you these disclosures. Remember, the Home Mortgage Disclosure Act says lenders must report loan data. Because it's useful for you when you go to litigation to expose discriminatory lending or misrepresentation. All right. 12 USC 5201 through 5261. All right. HERA, also
So he got the link,
PTFA,
so he said
stands
that
for
was
Housing
fast.
and
You're on the list for
Economic
tomorrow.
Recovery Act, also protecting tenants at Foreclosure Act. All right. The PTFA, post foreclosure new owner must honor lease and give 90 days eviction notice minimum. All right. It protects the renters. Next, we got 26 USC 860A through 860G. All right. Going over REMIC. REMIC stands for Real Estate Mortgage Investment Conduit. All right. IRS tax code. Loans must be deposited
Yeah, but
into
the
the
trader
REMIC
paper's been
trust by
activated.
a cutoff
I
date.
said it will be
Late
activated soon.
transfers
That comment
may
was-
void the trust's legal ownership claims.
No, he didn't respond yet.
All right. Also,
Call him.
UCC 3-301. Also 3-309. UCC Article 3. Uniform Commercial Code covers negotiable instruments. All right. 3-301 talks about only a person entitled to enforce may collect on the note. Okay. So if they can't even enforce, how can they collect? You have to ask yourself this. If they can't even enforce foreclosure, how can they collect? Now, should I stop paying my bill until the judge recognizes that? No, I should not. I should continue paying until the judge says that, because I can get all those payments back in restitution. Okay. Now talk about 3-309, lost note. Talks about party must prove prior possession. Also 12 CFR Part 226, Regulation Z. TILA implementation regulation, Federal Reserve. All right. Also CFPB. Details required APR, finance charge, and total payment disclosures. Non-compliance triggers TILA recession rights. All right. Now, we talked about you have the right to rescind the contract if it's any disclosure that wasn't given to you prior, because what if you wouldn't have agreed to that if they would have told you that from the get-go? All right. So that's why that's important. Also, 15 USC 5301, 5654, 5641, my apologies. Dodd-Frank and Dodd-Frank Wall Street Reform and Consumer Protection Act. All right. It also created the CFPB, grants authority to regulate servicers, file complaints. All right. Also, consumerfinance.gov/complaints. Also, Section 1022. Also in Section 1026. All right. So I wanted to definitely give y'all some resources. And again, you can go look this up on your own, or you can filter it in your free AI. Okay. Now, me personally, I would do both. I would put it into my AI and also look it up on my own, just so I can see it for myself, but also utilize AI so it can build me a good study guide. Now, critical mistakes homeowners make. Avoid these pitfalls. They can cost you everything. All right. Don't stop making payments immediately. A lot of people start thinking they can remember phrases and say, oh, I'm going to stop paying because I know I'm going to win. All right. Please don't be like the one to lose your home because you're going off of ego. All right. Please don't let that be you. All right. It says not paying escalates default. It does not improve your legal position. Challenge while staying current when possible. All right. Do consult an attorney before changing your payment behavior. Now, I have to put that up there for disclaimer purposes. All right. But I'm letting y'all know, do not stop paying. Okay. Going straight down. Don't fall for foreclosure rescue scams. Con artists charge thousands to audit your loan or file bogus UCC financing statement. These scams can make your situation that much worse. All right, because again, if you don't know the full process and just doing piece by piece, it still looks like a fraudulent act. All right. Do verify any provider with your state bar, free help, HUD, approved housing counselors. All right. I'm just giving y'all extra information, extra resources that you can use just to see if you can utilize it. Buy yourself some time.
Hello.
All right. Don't represent yourself in quiet title. Now, I'm going to say that to the ones that are beginners. Do not represent yourself and think you can do it just because you think you have to step by step. Okay. Remember, wealth takes time. All right. Be able to build a process that you can feel comfortable with being able to litigate. All right. It says quiet titles require precise pleadings, proper service on all parties, and knowledge of state property law. Okay. Pro se errors are often fatal, meaning beginner errors, all right, can basically kill your whole case. All right. Do find a real estate or foreclosure defense attorney. Many work on contingency, meaning you don't have to pay them until you win. All right. Or you can just pick their brain and see if you have a case. All right. And then go from there. It says, don't ignore deadlines. Many states have strict timelines for challenging foreclosure. Miss the window and you may lose the right to challenge the chain of title. All right. Do act immediately. RESPA, also the QWR, which is the qualified written request, and court deadlines are rigid and unforgiving. All right. Unless you have a great reason on why you missed that deadline, they could overturn it. All right. Your next steps. From awareness to action. Okay, Marcus roadmap is now yours. Number one, pull your deed of trust. This is what I want everyone to do. If you have a mortgage, if you are a homeowner, if you know someone that's a homeowner, okay, go over this stuff with them. Say, hey, this stuff is free. Let's go. Let's just see if they did everything correctly. It's not like we're saying we're not paying anything. All right. Number one, pull your deed of trust. Visit your county records website, search your name and property address, download the deed of trust and all records, all recorded assignments. Okay. Number two, send a qualified written request. Write a qualified written request, certified mail, return receipt to your servicer. Demand original note, all assignments. Okay. PSA and payment ledger. Number three, research your MERS number. Go to MERSregistrySolutions.com. Look up your loans, all right, MIN number. All right, see every investor and servicer who ever touched your loan. A lot of people don't know that they can do that. All right, comment 8 if you didn't know that you could do that. And don't lie if you didn't know. All right, it says find an attorney. Number 4, seek a real estate or foreclosure defense attorney in your state. HUD.gov also lists free or low-cost housing counselors. Number 5, file and fights. If chain of title is broken, file a quiet title action. Okay, record a less pendants. Hold every party accountable in court. Okay, always remember knowledge of the law is the beginning of freedom. Your title is your wealth. All right, you want to also guard it, family. All right, wealth mentorship program. Also, you want to go home with this as well. Wealth takes time. All right, stop rushing. I get a lot of people that rush and say, "Hey, man, I've been following you for 2 weeks, for 2 months, and I feel like I'm ready to take the banks down." Okay, that's not true, family. None of that is true. All right, at all. All right, somebody says, does Legal Shield help with this? Again, you can reach out to them. Okay, I'm not gonna say like they're just guaranteed. Again, we're just trying to pick their brains. You know, they may say things like, "Yes, you have a great case. Yes, oh man, you did all that yourself. Yeah, man, it's clear. You definitely have a case there." All right, and then go from there. Okay, so again, MERS, right? Now, let me ask y'all a question. How much do y'all think it costs to get started? How much do y'all think it costs to get started? Can everybody still hear me? All right, yeah, little to nothing. All right, little to nothing. All right. Only thing you're gonna be paying is if, let's say, if you want to, well, once you mail it, you know, you're gonna have to pay the little mailing fee, but that's pretty much it. Okay. But now let me ask y'all a question. Do y'all not know how many people are homeowners? How many homeowners do y'all think really looks this information up?
None of them.
All right. Now I know we only got 11 people here right now. Okay, but 11. Now we'll send for those that missed class. We'll send it to them. But for those that are listening right now, imagine how many people you know that doesn't understand about the chain of title, and they're just paying. They just paying. They just paying.
True. You be paying,
Imagine
don't even know who
paying
the hell you're
mortgage
paying to.
for 20 years, and then on the 22nd year, you miss payments, you get behind on finances, and you get your home foreclosed.
Paying everything.
Mm-hmm.
All right. Now you see how, you know, the more, not just me, okay, all right, not just me, but imagine y'all as well taking this and taking it to another level, because again, each one teach one, right? Because if y'all become homeowners, or if you are already a homeowner, imagine challenging title. Imagine being able to get your home free and clear. And then imagine somebody asks you, "Oh man, that's a scam. You didn't get your home free and clear. Man, stop scamming." Not even knowing you literally used the law. All right, and that's why again you want to keep things private, because again it's going to, you will find yourself in a "I'll prove you wrong" situation. It's not even nothing to prove. You proved yourself in court. All right, you proved yourself by not having to have payments anymore because you have your mortgage free and clear. You proved yourself because now you're about to go get all those payments that you came out of pocket in forms of restitution. Because how can they collect payments if they cannot foreclose? Remember, we have already cut their legs from under them when it comes to foreclosure. Now we're not going to stop there. We're going to take it further, a step further, and say, okay, they didn't have authority to foreclose, meaning they didn't have authority to collect.
Damn right.
Does everybody see what I'm putting together? All right, you have to be able to be creative, because again, they're not going to say, "Hey, by the way, all the payments we took from you as well was against our authority as well." The court is not going to mention that either, family. That's, you have to mention that. You have to express that. All right. Yes, that's definitely the combo. All right. Comment 8 if this is making sense. Comment 7 if it's not. All right. I need everybody to please participate. All right. Okay. So it really makes sense, because again, it's not rocket science, family. All right. I try to break this stuff down slow. All right. To this most efficient point, because again, I know a lot of y'all have homes. A lot of y'all know someone with a home. And being able to simply ask these type of questions before you start shoving tenders of payment down people's throats, or my negotiable instrument was refused. Okay, you can easily challenge chain of title. Okay, it's a well efficient
Yeah. He's saying besides people going out
approach,
there and they just
and it's
doing
basically done
tender
by just
payment for the
asking
notes.
questions. You don't even have to prove anything. You're just asking questions and seeing what they can't prove and using it against them. Okay. Now, that's pretty much everyone's homework if you are a homeowner. All right. Even if you want to become a homeowner one day. Okay, this gives you perfect preparation before you become a homeowner. All right, you don't got to go try to find a high-end home. You can find you a small house just to get in, just to kind of, practice with. Okay, because again, you might get in there and then see MERS as the nominee, wait 3 months to see when the assignment changes hands, then challenge the chain of title. You don't got to wait to years and years, family. It's all about when you locate the issue.
So
When
what
do
was they
you
supposed to do
raise
when they
the issue? All right. When do you bring it,
Freddie bought
to
the
the
thing
public?
and became the holder?
Okay. Any questions? Any questions?
I don't know. Well, it didn't move
Now we
something.
do have class this Sunday, family. The
And
reason why
since it
we didn't have
moved,
class
But if
last
they're not the
Sunday
holder, then why
was
is
because
Steve
of the asset acquisition class that we did. Okay.
So I want to know if that's
So
going to be
again, I
making sense
apologize about
of
the last 2 Sundays that
registering
we've
the next
done. I've
Sunday.
had a class on those Sundays. All right, but the next Sunday we will have class.
they're like
All right,
paying.
original class schedule.
Already stopped paying.
All right. We're going to be talking
I
about
got to
some
tell them.
more as far as
If you
acquisitions.
got any
All
questions.
right, how to basically place ourselves in position to acquire things, family. Because I know a lot of people want to get new cars. You want to get that new lease. You want to get that new apartment. You want to get that new home. All right. So again, that's what we're going to talk about this Sunday. All right. I kind of saved it for more so at the end of this month because I definitely wanted to show y'all this PowerPoint for sure. All right. For those that missed last class, hopefully you got the replay. We went over trust because if you do all this by way of a trust, it makes everything even more efficient. For those folks that have a home right now, let's say you haven't even challenged chain of title, that's okay. You still want to have a trust where you basically transfer that asset to the trust where now the trust owns it.
Yep.
Okay, because you can still do the same formula. All right. But that's pretty much it, family. I will have this recording ready for y'all tomorrow. Okay. Still, I would highly advise y'all go ahead and kind of get on, building this with your AI as well,
You said
saying, hey,
transfer to a revocable
help me
trust.
with some documentation where I can send out as far as a questionnaire, as far as challenging chain of title. Okay. Because again, you want to give no more than 30 days. All right. Give them 30 days to answer. If not, remember, that's a qualified written request, a QWR. If they don't respond in 30 days, it's damages. Okay. So that's pretty much it, family. With that being said, peace and love. Peace and love. I'm about to go live on social media right quick, Instagram, TikTok.
Damn.
All right. Talk to people for a few. Okay. But y'all don't have to join. I hope y'all do. But if you don't, it's cool. All right. But y'all do have homework. Get on it. Find out your state's quiet title statutes. Okay. Build with your AI. I'm going to be the guy that's going to tell y'all to build with your AI, family. A lot of people is going to try to gatekeep and not try to tell y'all, resources out here. But man, use that AI, family. Stop playing. Okay, stop playing. Use it. Go to it and say, "Hey, I have a mortgage. Here's my mortgage." You can upload your whole mortgage in your AI. Just say, "Hey, can you break down and see what's some things that's in there? That's probably some red flags that I can't see because I'm a beginner." You can ask things like that. I'm just saying, stay away from asking questions like this. Hey, get me out of paying my bills. Hey, get me all my money back. All right, you can't say things like that. All right. But with that being said, y'all, peace and love. And I'm going to see y'all Sunday. Peace, peace, peace.